And I agree with Ashley. Actually, this is one of my favorite trainings that we do. Not only because I get to do it with Ashley, but because this is a really kind of close to my heart topic, and I really like being able to present information to families and our community partners to be able to help people with disabilities um, live their lives.
Awesome. Okay, we are going to get started. Okay, so just to get us started, a little bit of information about what supported decision making is. It is a practice that we all use every single day, and that's when we reach out to our family members, our friends, our neighbors, people we go to church with, just people we know and we trust, to get help when before making, certain decisions. For people with disabilities, this new opportunity is going to allow them to continue to make choices about certain decisions in their own lives with the support of a team of people that they get to choose who those people are, and in what ways and in what areas they get to support them before they make certain decisions. It is now a legally recognized alternative to both continuing tutorships and interdiction. So I know I've already said that you use supported decision making, but if you didn't believe me, I want you to ask yourself like a couple of questions. Do you talk to your family members, your friends, your neighbors about issues and decisions that you have to make around, maybe it's a new job, maybe it's selling your home. It might be talking to a family member about a certain upcoming medical procedure, and you're looking for help and guidance from people who have either been through it, have some sort of knowledge or expertise in the area. These are people that you know and that you trust, that we reach out to every single day about our life choices. So the reality is, we all use supported decision making every single day, sometimes multiple times a day. We also still all make some bad choices or unpopular choices, even though we, utilize this option of supported decision making. So when it comes to individuals with intellectual and developmental disabilities, the facts are very clear when it comes to how they feel, and how being denied the ability to make decisions about their own lives, how that impacts them. So the facts are, when they're denied control over the ability to make choices about their lives, they all report feeling helpless, hopeless, and self-critical. I know when I feel like I don't have control over certain situations, I feel the exact same way. And then how we got here. Parents, especially those who have children with intellectual and developmental disabilities, have this fear. It is, I'm a parent of an 18-year-old, so I know the fear very well. And we are in IEP meetings, we're meeting with doctors, and that fear and that sort of sentiment about, I need to protect them. You need to do things to ensure that they're protected and that they're safe. What this has led to is an overabundance of individuals with intellectual and developmental disabilities, specifically being interdicted. And Melanie's going to get into what all of that means, so I'm not going to say much more about it. But these individuals don't have any control over their pretty much every single decision, that they're forced to make. Someone else is making it for them, and so these individuals are very much feeling helpless, hopeless, and very self-critical. So as supported decision making has it's become a much larger movement. More and more states are moving towards supported decision making. And so the data around the uses of supported decision making is also becoming very clear. And the individuals, that are able to utilize supported decision making, they report actually improved health outcomes. Both their physical and mental health has improved. They report being more independent, feeling more like and just better well adjusted, both in their personal life and out in the communities. These individuals also are able to find and maintain gainful employment and report feeling safer and more secure in their lives. So bad choices. As a parent, this is something that is scary when you have a child that has an intellectual developmental disability. What's going to happen to those bad choices? And I look back on all of the bad choices that I've made in my life, all of the growth that has come from those bad choices. And individuals with disabilities need that same opportunity that we were all given as young adults, making bad choices and growing from them. It might take a little bit more time to see the growth from those bad choices, but with the network and the team that supported decision making allows these individuals to create, it is very much doable. And these bad choices will sort of, I guess, improve over time. And but bad choices are not a good reason to take away somebody's rights to make those bad choices and make reasoned decisions about things very personal to them. So the principles behind supported decision making are really just around the rights that are afforded to people in our Constitution. And that is the ability to, people have the ability and the right to make their own decisions. And those decisions should not be dependent on the quality, of the decisions that were made. There's no one size fits all model. It's a lot like individualized education plans or IEPs in schools. So you should not have the same SDM agreement. You should not see the same agreement from one individual to the other, because the individual needs of those people are going to be very different and very specific. So the model is geared to work for everybody individually, just like an IEP has worked for them while they were in school. So why? Again, we all have the right to make decisions. It's in our Constitution. It's fundamental. Recognizing that we all need help. We all use SDM, again, every day. We all still make very unpopular decisions. We all still make bad decisions. But recognizing that individuals with disabilities are going to need support. It's going to look different for different decisions at different times. But we need to continue to remember that best practice is always to consider each individual's opinions and preferences. And this can be done even if that individual is already under an interdiction or in a continuing tutorship. And now I'm going to turn it over to Melanie, who's going to go over all of the different legal options that are available.
All right. And we can all see my screen okay? Perfect. Wonderful. All right. So before we talk about some legal status changes, first let's talk about capacity and competency. These terms are not the same, even though they're frequently interchanged. Capacity is not a legal status on its own. Capacity is a factor in determining competency, which is a legal status. So An individual's ability to make an informed decision is what we're looking at with capacity, right? Keeping in mind that informed is not the same as good. You can make an informed decision and still make a decision that is bad or a mistake or risky, right? Everyone deserves the dignity of risk to make bad decisions, to make risky decisions, to make mistakes, and then learn from them. Capacity ranges and it's fluid. And because of that, it can be better at sometimes than others, and it can also be hard to measure. So when you think about maybe individuals who've been diagnosed with sunsetters, they may have more capacity in the morning. And then as the day goes on, they may lose capacity. And then the next morning, they'll regain that capacity again. So it could be situational based. It could be even more short term than that. If you think about if anybody's ever had any kind of serious medical procedure, if you go under anesthesia, when you're waking up from anesthesia, you do not have capacity, right? But when that anesthesia wears off, you regain your capacity. So because of the influence of other factors, it can be a challenge to measure, right? The determination is usually made by a clinician. It is diagnosis based and therefore may be biased. Again, going back to sunsetters, right? Somebody diagnosed with sunset, they could say, oh, this person just doesn't have capacity, where in reality, they may have capacity at some times of the day, and you have to work within those windows. A diagnosis of a developmental disability does not automatically mean that somebody doesn't have capacity. Capacity is fluid. Capacity could change from one day to the next. Capacity needs to be measured. So simply because of the diagnosis, it shouldn't be an automatic assumption. There should be an evaluation and an affirmative determination based on the individual's factors. So then talking about competency, when we talk about a competent major is the legal status, right? Once you gain the age of 18, you gain the legal status of being a competent major. There's a presumption. As soon as you turn 18, you're presumed to be competent. What that means is every person is presumed to be a competent major at the age of 18, regardless of their circumstances, regardless of their individual factors. Under the law, they have a presumption that they are competent. And until a court says that the individual is not and changes that legal status from competent major to something else, they retain that presumption. They retain the status of being a competent major. So again, competency is the legal status. The decision as to competency can only be made by a judge. Capacity is what's made by the doctor, given to the judge, and the judge can determine whether or not the person is competent. If a judge has not found someone to be incompetent, they are competent. They remain competent under the law. So the determination as to whether or not somebody is competent is evidence-based, and it's a functional determination rather than a medical determination. So the medical determination is the capacity, right? Do they have the capacity to understand? And then the competency is looking at, are they consistently making well-reasoned decisions? Are they participating in decision making? Do they understand if it's explained to them? Do they understand the pros and cons? Do they understand the factors into a decision? Do they understand what's happening around them? Do they have the ability to understand what's happening around them? All of those things are considerations when determining that the judge will use when determining competency. It can also be issue specific, right? So it can be specified to certain areas and may not be across the board. So an individual may be competent, may be found competent by the court as to all areas except maybe for a succession. So someone passes away, there's a succession, they've inherited a house, and maybe they don't have the capacity to understand how to sell a house or the inner workings of real estate. It's complicated. I struggle with it. So if an individual may not have the capacity to understand that, the court may determine they are incompetent as to handling their succession and dealing with the sale of the property, and therefore may change that individual's legal status only as to that issue. And then once that issue is resolved, they retain their legal status of competency as to all other areas of their life. So again, it's very issue specific, it's evidence-based, and it's the judge will determine what's most appropriate to protect the individual while allowing them to retain as much autonomy as possible. Back to this again, the presumption of competency does not always equate to informed decision making, right? So again, as adults, we all have the right to make bad decisions. We all do make bad decisions. I have made many bad decisions. My worst bad decision was smoking. I was a smoker for years and years and years. It was a very informed decision. I was well aware of the health complications that could happen in the very nebulous universe of possibilities. I was also acutely aware of how it was impacting me personally in my personal health. And yet, I continued to make the decision, the bad decision, to continue to smoke until one day I decided enough was enough. So a person can also be legally competent, but lack capacity, right? So again, with that presumption of competency, until the court says they're not competent, they retain it, but they may not actually have capacity to understand. So if a person has no way to communicate his or her wants or needs, they may lack capacity. But until the court says otherwise, they remain the competent major. So due to issues, it may sometimes be appropriate to change someone's legal status. So what does that look like in Louisiana? So in Louisiana, we have a continuing tutorship and an interdiction. Those are the two changes to legal status that exist in Louisiana. Then there are alternatives, a lot of alternatives to changing those legal status. One of them is power of attorney, and one of them is supported decision making. There are a number of other alternatives to address specific needs, and we're going to talk about those in turn. First, let's talk about tutorship. So with this year, there have been amendments to continuing tutorship law. One of the big amendments is that it created the option for both a full and limited tutorship. It also changed the language around who is may be eligible for tutorship to include children with any disability, not just an intellectual disability, which, in my opinion, unreasonably expands the law and no longer meets the purpose of what the law was originally created for. It also then clarified that a continuing tutorship is only terminated by the court. That is the only way that a continuing tutorship ends, which necessarily creates a lot of issues for these children as they grow into adults, and especially as parents pass away, because it leaves these children who are now adults under a continuing tutorship with no one to step in as the decision maker and with no alternative to substitute anyone, because a non-parent can't substitute in as a tutor over a child. An entirely new proceeding would have to take place to either terminate or remove the tutorship, or interdiction proceedings would need to be brought to appoint another human to make decisions. So the continuing tutorship for disabilities, a child who is over the age of 15 but under the age of 18, so a minor, right, who has not attained that presumption of competency, who possesses less than 2/3 of the intellectual or adaptive functioning of a person the same age with average intellectual or adaptive functioning. Now, if anyone is able to actually explain what any of that means, that would be delightful. The problem with the law is it's so vague, it's written so very poorly that it can be manipulated and expanded in ways that are not helpful and don't actually benefit children with disabilities. It requires evidence by standard testing procedures administered by competent persons to make this determination as to whether or not the child is eligible. And it shall not automatically end at any age, but continues until revoked by the court. The effect of a continuing tutorship is a child's rights are restricted to those of a minor, unless the court restricts them further. So in layperson terms, it causes the child to be a permanent minor throughout the pendency of their natural lifespan. Unless, of course, the court restricts those rights even further, which it's possible now under the revisions that the court could do. So currently under the law, under the voting law, it's silent as to tutorships. So we've always advocated that if an adult is under a continuing tutorship and wants to vote, that there's nothing restricting them from voting. However, under the revisions to the tutorship law, a court could restrict the rights of that adult to vote. Now, mind you, the rights are being restricted when the human is still a child, still a minor, still not done developing. So when that child then becomes an adult and they may or may not have capacity to understand things like voting, and they might be interested in voting, they may not be able to because a court has restricted them when they were a child. So why are continuing tutorships unnecessary? Well, that's because the tools that parents need to protect their kids already exist. There are provisions in place in the law that already exist to deal with medical decisions. There's provisions in the law that already exist that can help parents help their children deal with financial decisions. All of these things already exist in the law. They don't come with the same financial price tag that a tutorship does, because with a tutorship, you have to pay for lawyers, you have to pay court costs, you have to pay filing fees, you might have to pay for a medical evaluation. It can get expensive. There are things that exist that may not come with the same financial price tag that does. And it doesn't strip the child of their rights before they've even developed enough to gain actual capacity to whether or not they can make those decisions. And so let's talk about some of them. The first thing is, medical consent law. So there is a hierarchy of consent for decisions that already exists in statute. Here it is at the bottom. You can look it up. It gives you a list of who can step in and make decisions if at the time of treatment, the doctor has determined that this human does not have capacity to consent for themselves. So let's say I went to the doctor and the doctor said, Melanie doesn't have capacity to consent to this treatment, whatever it is. The doctor and or my family or whomever can go to this list in the law and say, okay, well, who's next on the list? So if an adult for myself is not capable, next would be the judicially appointed person. If there's not one of those, if there's a spouse, that would be next in line. If there's no spouse, then an adult child. If there's no adult child, then a parent. If there's no parent, then a sibling. If there's no sibling, any other living relative. If there's no other living relative, there are 3 or 4 other options that come after this short list that are there. Included on that list is the IDT team. And the law very clearly defines who should be a member of the IDT team in the event that there are no other humans before that on the list to make a decision for consent for medical care. This provision is in the law. It already exists. It's already an available option. So even in the face of a child who may not have the capacity when they, become an adult to make medical decisions, the parent can continue to step in to make decisions on behalf of the child per the law, and it costs nothing. So what about if there's financial decisions? Well, firstly, and I don't have a slide about it, but the first thing could just be a joint bank account, right? What better way to help teach your child how to manage money, how to deal with finances, than for you and the child to have a joint bank account together? The parent can oversee the spending, can oversee what's happening in the account, can have notifications early enough to be able to step in and take action if something goes real sideways, and to help the child to learn. None of us had any idea how to balance a checkbook, pay bills, or manage our finances before someone taught us. So it's only appropriate that we give children with disabilities the same opportunity to learn and grow those skills that we had. There's also the option as for representative payees. right? So the representative payee program is with Social Security benefits. So for a child who receives Social Security benefits, the parent can go to the Social Security office and apply to be the representative payee. What that means is the parent would receive the benefit from Social Security on behalf of the child. And then the parent would need to keep it in a separate account, can't commingle funds, has to spend the money in accordance with the law and the intent and purpose of the money for the child, all of those things. Um, it's also not only for parents and children, right? Representative payee is something that's available for any adult who is receiving Social Security benefits. And either the individual on behalf of themselves, or maybe someone else says, I'm concerned that, the beneficiary doesn't have capacity to understand the Social Security benefits or is at risk of financial exploitation or something, can go to Social Security, apply to be the representative payee or to change the representative payee, and then Social Security handles it from there. There's also an ABLE account. So if an individual comes into a sum of money, or if an individual isn't spending down their Social Security benefits every month because maybe they have waiver, or maybe they have some other assistance and they don't have to spend much in housing and they don't have a lot of other expenses, and to ensure that they're not just collecting money that could impact their eligibility for benefits, ABLE accounts are available. The last I looked at it, and it might have changed, uh, but I believe it's $15,000 a year that can be put into an ABLE account. I'm not sure if that updated this year or not, but there is this really, really valuable, helpful website that gives you all of the information about ABLE accounts, how they work, how they function, how they operate, how you open them, the things that they can be spent on. But it enables money to go into an account for the use and benefit of the individual with a disability without impacting benefits. This money could be used as a vacation fund, right? So if families want to ensure that maybe their loved one has the ability to go to the beach once a year, they can put money into an ABLE account and say this is their vacation money. And then that money is used for vacation. Once a year, they go to the beach. And it doesn't impact their eligibility for public benefits, Medicaid or SNAP benefits, or Social Security benefits even. There's also the ability to open a different type of ABLE account. So each state has their own rules around ABLE accounts, right? So they have different offers. So you can go to the website and look through what different state accounts offer and find an option that maybe works best for the individual. Maybe the individual isn't going to be withdrawing money on a regular basis. Maybe it is only a once a year thing. So maybe there's an account that charges no withdrawal fees, but limits the amount of withdrawals that can happen. Maybe that would work for the individual. Maybe the individual needs to take out money frequently and so needs to have unlimited withdrawal options. And maybe it would be worth it to pay a nominal fee, uh, $4 a month or whatever it is, to be able to have those unlimited withdrawals. So there's a lot of options available within the ABLE accounts to be able to find something that will work best for the individual. If there's something that comes up that's a much larger sum of money, so going back to the inheritance and opening a succession, that can't go into an ABLE account, and we need to ensure that we're protecting both the individual's eligibility for public benefits, but also shielding that individual from the possibility of financial exploitation. There's a special needs trust. A special needs trust is also an option to shield from eligibility for public benefits, but a lot more things can go into it, right? You can put a house in a special needs trust. Maybe the individual wins a large sum of money from a legal settlement. That can go into a special needs trust. There are, again, rules in place about what the money can and cannot be spent for. There's a trustee that can be put into place depending on the amount of money. The trustee could be a bank. So it truly is a very neutral person. And the trustee will ensure that the money is only being withdrawn for appropriate purposes, that is not being overused, that's not being financially exploited. And so it protects the individual's financial interests while still enabling them to have access to things above and beyond what their public benefits would pay for. Another less restrictive option that's available to removing someone's autonomy, the power of attorney. right? So a power of attorney is a legal document that allows someone else to act on your behalf. So it could either give very broad authority or it could give very limited authority to make decisions regarding property, finances, medical care. And it's all dependent on what the individual wants, right? So I could give a power of attorney to my mom to make all of my financial decisions. It could give her access to all of my bank accounts, to all of my pay accounts, and she just has unfettered access to do whatever she needs in my name to handle my finances. But I don't want her to have anything to do with my or with my medical decisions. So I can write that very clearly in the power of attorney that says she can do X, Y, and Z, and that's it. And then that's all she would have the ability to do. I could also write it in very narrow and say, my mom has access to my bank account for the purpose of paying my rent, my light bill, and my cable bill, and that is it. And so then she wouldn't have any access to deal with my phone bill because that's not included in the power of attorney, right? So it can either be as broad or as restrictive as the individual wants. So it can ensure that the individual is being protected, right? If there's a concern about any kind of exploitation, but it also enables the individual to get assistance when they want it, when they need it, without having to, again, strip them of their right. It doesn't take away their right to make decisions. It just enables another person to step in to make decisions when they want them to. Also, because Louisiana, and we make up our own words for things, a power of attorney in Louisiana is also called a mandate. So, same thing, different words. Um, It is something that needs to be created by an attorney, so it could come with a small cost, but there are a lot of attorneys that are willing to draft and create powers of attorney for relatively low cost. And there are a number of attorneys that will either do them pro bono or low bono, which means the low fee. So again, a power of attorney is to confer authority on another individual to act on someone's behalf, does not take away their right to make their own decisions. So a competent major can grant the power of attorney to allow the representative to act however they want. It can be revoked at any time. It can be changed at any time. And it doesn't require the individual to be incompetent in order for it to take effect, right? So it's called a durable power of attorney or a durable mandate, meaning it's effective the moment that it's signed. So it can not only be used for financial decisions, it can also be used for medical decisions. It's also referred to as a healthcare mandate, a healthcare proxy, medical power of attorney. And it enables the individual, while they have capacity, to be able to talk about what they want medically to happen or not happen at a time that they might lose capacity, right? So, say if an individual had a strongly held belief that they didn't want to have a blood transfusion, for example, for whatever reason, doesn't matter. They don't ever want a blood transfusion. They could create a medical power of attorney or a healthcare proxy or a healthcare mandate that says, in the event that I am incapacitated and unable to provide consent, I am withholding consent from ever receiving a blood transfusion under any circumstances. They would have that document. That document would be given to their doctor, right? So in the event that something happened to them, they weren't able to provide consent, the doctor would be able to refer back to that document to say, this is what they do or don't want. Things like this are commonly done when there's an irreversible or a terminal life condition in order to make sure that the individual's end of life care is known to their doctors. But that's not the only time that it can be created, right? I strongly encourage all people at all times, everywhere, to have a power of attorney in place somewhere, because my example is always I could get hit by a bus tomorrow, and I would need my people in my life to know who does what with my finances, who's dealing with my healthcare, who's dealing with custody of my child, like what's happening with all of these things. It's important to have them documented and written down, but it's extra important for people with disabilities to be able to have that say so over the decisions that are being made, and to authorize another person to be able to step in to help them when they need it. So just as a difference, In Louisiana, it's called a durable power of attorney. Other states refer to it as a springing power of attorney. So if there are people with loved ones in other states, or if an individual who has lived in another state moves to Louisiana, if their power of attorney is called a springing power of attorney, that means that it's only effective when the grantor becomes incapacitated. Whereas, like I said, the durable power of attorney is effective as soon as it's signed. So that's just kind of the difference between the two. And it's just something to be mindful of if there are people who are across state lines. So the other change, those are some of the less restrictive alternatives. So I want to talk about the other change to legal status, and that's interdiction. So a full interdiction is when an individual is unable to consistently make reasoned decisions regarding the care of his person and property, or communicate those decisions, and whose interests cannot be protected by less restrictive means. So breaking that down, it's an individual who's an 18 or over, so somebody who's attained competent major status, or an emancipated minor, which is a very rare circumstance, is unable to consistently make reasoned decisions regarding the care of person and property. If it's or property, that's when you're considering a limited interdiction, which we'll talk about in a second. Or is unable to communicate those decisions in a manner understandable by others. That means any manner understandable by others. So if the individual is only able to communicate via ASL, for example, that is a method that is understandable by others. Just because everyone doesn't know ASL doesn't mean that individual is incapable of communicating. They just communicate in a different way. So, and the individual is unable to care for their person and property due to an infirmity. Now, the infirmity must be a condition serious enough to cause a significant impairment on the exercise of judgment. Chronic substance abuse could qualify depending on the circumstances. Advanced age alone does not, nor does a diagnosis of a developmental disability. That alone is insufficient to qualify for interdiction. There has to be the showing that the individual is unable to consistently make reasoned decisions. So with the passage of the Supported Decision-Making Act came the First Amendment to interdiction law since, I think, the 70s. Now, a person who's seeking to interdict an individual with a disability must prove to courts that less restrictive options were tried. If they weren't tried, why? If they were tried, why did they fail, right? Why didn't they work? And all of this has to be included in the original application or petition to the court seeking to interdict the individual. A full interdiction is the most restrictive remedy. It has been described by the Supreme Court as a civil death. It's the most intrusive remedy, and it's often more sweeping in its effect than necessary. So you think all the legal rights are transferred to another person. So I want you to think about all the rights that you might have as a bundle of sticks, right? So included with the rights that are supposed to be transferred, all of the legal rights that are supposed to be transferred, it includes the right to contract, the right to marry, right? Because those are all legally binding things. The right to accept or renounce a succession, the right to sue or be sued, the right to vote, because it's specifically enumerated in the voting law that people under full interdiction are not permitted to vote. But there's also a lot of other rights that are included in this stick bundle, right? Which includes the right to drive, the right to consent to medical treatment, leave the state without permission, decide where you live, decide who you associate with, whether or not you spend time with your family, whether or not you have relationships, whether or not you have sex, what you wear, what you eat, what you do you have a job, what do you do for fun, where do you get to go in your free time, do you get to have free time? All of those decisions are included in your stick bundle. And under a full interdiction, more often than not, that entire stick bundle is taken away and given to another person who then makes all of those decisions for you. The only right that a person under a full interdiction retains is the right to challenge the interdiction or to challenge the curator, who's the person who's put over them, and to retain an attorney to do both of those things, because you can't do those without a lawyer, right? A court can only modify or terminate a judgment of interdiction when it finds by a preponderance of the evidence that the terms are excessive or insufficient, or that the ability of the interdict has changed. Otherwise, the interdiction terminates at the death of the interdict, not the curator. So a few things here. A preponderance of the evidence means that it's more likely than not, right? The death of the curator does not change situation for the interdict in a positive way, right? What it does is it leaves the interdict in this weird gray area, no man's land, where there is no one to step in and make decisions. The undercurator, the role of the undercurator is not to step in as curator. The role of the undercurator is supposed to be to oversee the curator, to ensure the curator is doing the things the curator is supposed to do, like filing and accounting with the court, or not abusing or neglecting the interdict, or ensuring that the interdict's needs are met. So the undercurator and if the curator dies, the undercurator has no inherent authority to step in. In order for someone to take over, someone would need to go to court and ask the court to appoint a new curator, which again costs money. So an individual under an interdiction without a curator is left without anyone to actually legally make decisions for them. So a limited interdiction, let's do the shortened version. A limited interdiction is intended to be less restrictive than a full interdiction. The intention is that the limited interdict retains all of their rights except for those that are specifically granted in the judgment. So the intention is the court would only confer those powers that are required to protect the interests of the interdict onto another person, and the interdict would retain all the rest of their rights, right? That's how it's supposed to be written. So like my earlier example with the succession, the limited interdiction would say, the court confers authority onto curator to settle the succession and deal with the sale of the home. Once that's over, the limited interdiction ends. The interdict retains all the rest of their rights for all other decision making. The problem is the orders are typically not written with specificity, and they're written very broadly to read the same as a full interdiction. So just a couple of important last minute things to note about interdiction. A reasoned decision, you guys are going to get sick hearing this. A reasoned decision can be a risky or poor decision. It can be a bad decision. Risky, poor, bad decisions are not sufficient reasons for interdiction. Everyone has the right to make mistakes. Everyone has the right to make bad decisions. That alone should not be a basis for an interdiction to strip somebody of all their rights. Unable to communicate reasoned decisions. If the individual can communicate in any form, whether it's verbal or nonverbal, they're not a proper candidate for interdiction. It's important to consider and know less restrictive options first before you try to take away someone's autonomy. And that's not to say that interdiction or tutorship may not, in certain circumstances, be appropriate, but it shouldn't be the first step. It shouldn't be the initial response. Under the law, it shouldn't be the first response. So then the least restrictive option is supported decision making. And then with that, I'm going to pass it back over to Ashley to talk to you more about that.
Can you all see my screen?
We see that not the presentation mode.
How about now?
There it is.
Okay, perfect. My button was not responding as quickly as I wanted it to for some reason. Okay, so supported decision making is the law around it is known as the Dustin Gary Act. This is a picture of Dustin. He is now a 23-year-old young man. He is the son of Liz Gary. Some of y'all might know her if you've been through Partners in Policymaking or through the LEND program at LSU HDC. This is her youngest son. We were super excited and honored to be able to name this after Dustin, and he was the first individual that I worked with through this contract with the DD Council through our mentoring part of the program, and was able to get him set up, and he utilizes supported decision making today. So the Arc of Louisiana partnered with Disability Rights Louisiana. We also worked alongside People First of Louisiana to bring this legislation, you know, to people's, we brought it up, got legislative support behind it, made parents aware of the change, and this piece of legislation flew through the legislature without any opposition back in 2020. Representative Paula Davis and now Senator Franklin Foyle were the two primary authors of this piece of legislation, but it was truly a collaborative effort between both advocacy organizations and the Office for Citizens with Developmental Disabilities, working together to bring this opportunity to individuals in Louisiana. So besides allowing individuals with disabilities the opportunity to remain in control over decision-making in their lives, I have found that supported decision-making really does way more than just that. And these are some of the other things that I have found as I've mentored about 18 individuals through this process. Better understanding information, issues and choices that they're going to have to make, teaching them how to weigh options. I mean, I remember when I was growing up, my mom taught me how to weigh options with an Excel spreadsheet, and I had pros in one column and cons in the other. And I would literally write down what were all the pros, what were all the cons, so I could very easily visually see that the decision I was about to make was either going to have a positive outcome or a negative outcome. And for a long time, I still chose to make a decision that would have negative outcomes until I was finally able to fully understand those negative impacts. And so this is just one of the things that I feel like has really, especially with parents, help them get over some of those fears about, you know, what's going to happen if they make that bad choice. Are they really going to learn from their mistakes? And as they have gone through this process, seeing that supported decision making really benefits, you know, their kids in so many other ways. They're seeing them grow. They're seeing them, you know, make well-informed, reasoned decisions that aren't always risky or unpopular, you know, or bad. So it's really just, for me, it's helped. And we created a supported decision-making document for my son when he turned 18. And how quickly I realized that there were a lot of things that I did that I thought I would never do, just out of fear, things that I didn't expose him to, not on purpose. I don't feel like I did it with any, you know, ill intent. I just didn't do things the same way I did them for his older sister. And how quickly he was able to visually see the difference between how many things were in the good column versus how many things were in the bad column, and how he quickly, since March, has been able to start doing some of these things, you know, on his own, and say, you know, I really shouldn't have, you know, I really shouldn't make this certain decision because I've got way more things in, you know, in the negative, and maybe I need to make a decision, you know, the decision not to do this because of that. It also helps with ensuring that just everyday decisions, whether they're big decisions or little decisions, are just based on their preference. This is super important, and sometimes it's starting with the little things. that can really help build their confidence and improve their decision-making ability. So when they get and have to make a big decision, they're confident in it, and what they have tried and what they've put in place for little things works. So it's more than likely going to work for those big decisions. And then one of the most important things is how they communicate those decisions to other individuals. And when I get into talking about the role of a supporter, I find that one of the most important roles they have is helping that individual communicate decisions, especially if it's to a parent or a sibling or somebody that is going to say, well, that's a bad choice or that's a risky choice, is helping them communicate those, those risky choices, those bad choices to other individuals. So who can use supported decision-making? The law is very clear. It says that it has to be an adult with a disability defined by the American with Disabilities Act or the ADA, who is at least 18 years of age or who happens to be an emancipated minor. So how do you know if SDM is something that you should look into, something that you might want to try? Well, just like everything else in life, you don't know until you give it a shot. But going back to what Melanie touched on earlier, the law is also very clear on trying least restrictive options before moving into something like a continuing tutorship or any type of interdiction. So for my visual people, I put this slide on here because it's the best visual explanation of supported decision-making. So at the center of this entire picture is a young man who makes his own decisions with the help of a supporter. And you see a picture of him and one of his supporters. And all around him are the areas in his life that he has decided that he needs support from certain people during certain times. So some of those are where he wants to live, his medical care, how he spends his money, where he wants to work, who his friends are, and in voting. So he is at the center of it all, and he has decided these are the areas where he needs some help, and this is his supporter who helps him when making certain life decisions. So now we're going to switch gears to talking about supporters. So let's talk about who they should be. First and foremost, it needs to be somebody that the individual trusts, who they know, and who is willing to go on the journey of supported decision-making, because it is a journey. It is a lifelong journey, although there should be changes, throughout that individual's journey. It's going to be somebody that fully accepts the individual and supports the individual, wholly. Someone who's got some knowledge in a particular area that the individual is looking to include in their agreement. So I'm not saying that the supporter has to be a registered nurse or a doctor. If that individual is looking to, to get support around medical decisions, doesn't have to be a stockbroker or some type of financial planner, or a banker when it comes to financial decisions, but you don't want it to be, your son's best friend or your daughter's, friend from church. You want it to be somebody who's got some experience when making decisions around healthcare issues, who is going to be able to lead the individual to making sure that they have all of the information that they need. So somebody who knows how to reach out and get additional information, find additional resources. So again, doesn't have to be an expert in a like financial situation or healthcare situation, but you definitely want it to be somebody who's got some knowledge in those particular areas. Somebody that can be available long-term. Again, as the individual grows in their ability with making certain decisions, you would expect to see less support needs in the agreement. So you would expect the agreement to change over time, but don't go in developing a team with that in mind. So go in looking for people who can commit to a long-term agreement. And if changes come up along the way, great. But don't go looking for people for like 6 months at a time. You need to go in looking for a long-term commitment. And then you want the supporter also to be super open, very flexible, who is going to be able to keep the individual at the forefront and quote unquote the agenda. So they're not going to exert any type of undue influence on this individual and try and sway the decision that that the individual is about to make. So once you have identified who you want to be a part of your team, the next step is obviously reaching out and talking to them about it. So how they do this is however they want to do it. They might want to bring everybody together and talk to everybody all at once, or they might want to talk to each of their supporters individually. It really just, again, depends on what the decision maker, the individual with a disability, how they want to go about talking to their supporters. However that goes, it's super important during the conversation that all of the potential supporters, or if there's just one, the supporter fully understands what's involved, fully understands their role, and what it looks like fulfilling the role of being a supporter, and understands everything before anybody goes forward with signing the agreements. So just some things for the decision maker to share. Of course, they're going to be the areas in which they're looking to get support from their supporter. Sharing how they want to get that support. I think it's also equally important to share how they don't want support given to them. I think it's also important to share a sample supported decision-making agreement, so the supporters have an idea of what the agreement is going to look like, although nothing has been filled out yet. So in the law, we were very specific on spelling out what a supporter can do and what a supporter cannot do. So in their role, they are able to provide supported decision-making, and that can include assistance in understanding all of the options that are being presented to them, any responsibility that's going to fall back on the decision maker after they make a certain decision, any type of consequences that could possibly happen if they make a certain decision, but they can never make those decisions on behalf of that individual at any point. They don't ever have the ability to do that. They can also help the individual accessing, collecting, and obtaining any type of information that's needed and is relevant to a given life decision. And this can include medical, financial, educational, any type of treatment records, psychological records. They would, again, and we'll talk about this a little bit later in the agreement, they have to get the consent to do that. But if given the consent, that is something that a supporter is allowed to do. Another thing that they are allowed to do is help the decision maker understand information that is being described to them. So for example, if you are a supporter for your child around medical issues, and you are going to the doctor with them to talk about possibly an upcoming procedure that they are recommending that your child receive, you could go with them to this appointment. And then after y'all leave the appointment, you can continue to work with them to understand and make sure that they are fully, clear on this is the procedure. This is what's going to happen. If you don't do it, here's what's going to happen. If you do it, here's what's going to happen, to help them work towards making, their decision on this particular upcoming procedure. You can also, and I talked about this a little bit earlier, being a supporter, assisting them in communicating decisions to appropriate parties, especially in the areas of a risky or unpopular or a decision that's going to be viewed by somebody as being a bad decision. It is probably one of the most important roles that a supporter is going to play, is supporting them in communicating some of these decisions. So we spelled out very clearly, also in the law, what supporters cannot do. They cannot ever exert any type of undue influence on the individual, cannot try to persuade them, guilt them into making certain decisions. They cannot obtain any of that, like medical, financial, educational, protected information without the consent. And you have to be in the agreement. It has to be very clear whether consent is given. Cannot ever act outside of the scope of the agreement and the authority that the decision maker has given in that particular agreement. So let's say you are a supporter for financial decisions. You can't start talking about healthcare related topics or employment topics that is outside of the scope that you are in the supported decision making agreement as. You were in there solely for financial decisions. So you have to stick with the areas that the decision maker has asked you to be a supporter for. And then also obtaining without the consent any type of non-public personal information related to the individual. So being an effective supporter, I will tell you from personal experience, just from the last couple of months, it is a very rewarding position, but it is not always easy. Having to set and maintain very clear boundaries, can be difficult at times. Trying to maintain and seek common ground can also be difficult at times. But like I said, it is one of the most rewarding things I have ever done, for and with my son, is being a supporter for him, watching him learn how to make decisions, how to learn from bad choices, that have been made, again, has really been some of the most rewarding months that I've had with him over the past 18 years. Another area where I feel like supported decision-making really does benefit adults with intellectual and developmental disabilities is understanding how to build and maintain healthy adult relationships, learning how to talk about respect and people's personal boundaries, how to understand and learn to expect differences of opinion. We live in such a polarized world today. This is difficult for those of us that do not have an intellectual or developmental disability. So it's even more difficult for them, but supported decision-making is just another tool that is really helping those individuals understand differences of opinion in worldviews and how to respect our friends and our neighbors and our loved ones that have views that are completely different from us. Learning how to make room for change and recognizing growth in certain areas, being able to learning how to agree to disagree, and just realizing that it's okay to and be able to recognize that we're never going to agree on a certain topic, but their opinion on it is no less valuable than mine. This has probably been one of the most hardest things for me and my son, because he feel like he's right on everything, and sometimes I feel like I'm right on everything. So it's really helped us get through some difficult things, and learning to just fully respect each other's opinions on things when we're not going to come to the same decision. So supporters have been identified. Everybody's in agreement. The next step is filling out the SDM agreement itself. So the decision maker is going to meet with the supporters. Again, how they do that is dependent on what the decision maker wants and what works best for them. They need to go over the agreement line by line, page by page, make sure that everybody fully understands and agrees upon what is written out in that particular agreement. Again, it is super important to remember to share with the supporters not just the type of support that they want, but also the type of support that they do not want, and how that support is given is super important for supporters to understand. This is a sample agreement that we very quickly created after the law passed. The nice thing about this law is it doesn't require the use of a standard form. It does require certain things have to be in the agreement, but you do not have to use this specific form. You do have to have in it certain things, and we will go over those right now. So the agreement has to contain the name, the address, and phone number of at least one supporter. If there are multiple supporters, I always tell the individuals that are, working with me that you need to list all of your supporters. You have to include in the agreement a description of the assistance that the supporters are going to be providing. And if there are multiple supporters, how is everybody going to work together? That has to be spelled out in the agreement. You have to have both the signatures of the decision maker and the supporter or supporters, and then the authorization for a supporter to share any type of information with another supporter or any others that are named in the agreement. So are supported decision-making agreements voluntary or court-ordered? These are a very simple, this is a very simple option, does not require reaching out to an attorney for any type of advice. You do not have to go to court for anything. This is an option for an individual when they decide they need specific help around certain areas that they're looking to make decisions in their life about. And the individual and the supporter or the multiple supporters enter into this agreement voluntary. The only thing that is required with a supported decision-making agreement is the agreement has to be notarized. So this is probably one of the most common questions that we get is how is this different from a power of attorney? The only difference really between these two things is a supporter does not ever have the ability to make decisions on behalf of the decision maker. Even if that decision maker is in a car accident and does not have the capacity to make decisions, if there is no other legal document in place, a supported decision-making agreement does not give you the ability to make decisions on their behalf. The person, the decision maker, the person with the disability retains all of their rights at all times when it comes to making decisions about their own lives. So with the confidential information, it talks about this in the authorizations that are required. A supporter can be authorized to assist in collecting, accessing, and obtaining information that is confidential. This would be medical information that would be protected by HIPAA, and educational records that would be protected under FERPA. If the decision maker grants this authority to a supporter, the supporter has to ensure that this information is kept privileged and confidential and isn't ever subjected to any type of unauthorized access or disclosure by somebody else. Example, I'm a supporter for my son with health care related decisions. I have authority to help with information protected under HIPAA. And I'm throwing a huge family barbecue. And I've got that information out on my dining room table, but I'm going to have my in-laws over. He's going to have some of his friends over. My daughter's coming. People that are not given the authority to access this information would have potential access to it because it was out on my dining room table. So just like you don't want other people seeing your personal information, if you are given the authority to access this type of information, you are expected to keep that information confidential at all times. So you can't just leave it out on your kitchen counter, your dining room table for people coming in and out of your house to potentially see or get access to. Just a keynote, if you are authorized to assist with this type of information, if they choose not to use you, they're perfectly able to do that. They do not have to reach out to you for assistance when it comes to this. They can do this without it. So again, if they have given you the authorization to do this, but decide not to call you to get help with it, they're just going to do it on their own. That is perfectly legal for them to do. So there are a few ways that an agreement comes to an end. The decision maker, the subject of the agreement, if they would to pass away, the agreement obviously would come to an end. The individual has the ability to revoke the agreement at any time. So they can decide to personally end it for whatever reason they want to. Or a supporter might decide, you know what, I've been doing this for a couple of years now. I have some other things going on in my life, and I'm just not able to continue to dedicate the amount of time that I've been dedicating to this. And so they would revoke their participation in writing. A supporter does not have any ability to recommend or name somebody to take their place. That is solely the decision maker or the individual with the disabilities decision to decide who their supporters are going to be. And the other way that an agreement can come to an end is if a court has determined that one of the supporters in the agreement has committed any type of financial exploitation, abuse, or neglect of the individual. So in the law, we put in some protective language and requirements around if somebody suspects any type of abuse. So anybody who receives a copy of the agreement is aware of the supported decision-making agreement, and they believe that the individual is being abused, neglected, or exploited by any of their supporters, they are legally required to report that to either the Adult Protective Agency or any of the local or state law enforcement agencies. And our Adult Protective Agency is Adult Protective Services, or APS. They are the organization that is responsible for investigating any of these claims and reports that are being made. And you can report any suspected abuse 24 hours a day, 7 days a week, and that is the toll-free hotline. So can you use SDM alongside other alternatives to interdiction? And the answer is yes. I use SDM alongside power of attorneys for my son, and it is really consistent with the overall goal around promoting self-determination, improving individuals with disabilities, abilities to make reasoned decisions over time, and help avoid any unnecessary interdictions or continuing tutorship. So I recommend that you use SDM everywhere, incorporate it into any and all plans, and write them into IEPs, CPOCs, IPs, any plan or program that this individual is in. Let people know, make them aware that this individual is utilizing supported decision making. Encourage them to share the agreement with everybody, so everybody knows I'm utilizing supported decision making. This is what I'm doing. So if you haven't already figured out, supported decision making is hard work. It requires the building and maintaining of those healthy adult relationships. It requires time. It requires a long-term commitment and open communication between a group of people, a group of supporters. You might not know some of them. And it's important that everybody stays committed to the individual, and keeps that individual at the forefront and maintains them being the agenda throughout their time as being a part of a supported decision-making team. Some last things to remember: the law presumes that all adults, and Melanie went over this in her part, have the capacity to make their own decisions. This includes people with intellectual and developmental disabilities as well. Decision making is a learned skill. It takes time and it takes failure. It takes learning how to take a bad decision, unpack it, and do better the next time. And that's scary for parents who have kids with intellectual and developmental disabilities. I don't know why it's harder, but I find it way harder to put that into practice for Cooper than I do my daughter. There are so many other less restrictive options and legal options available when it comes to decision making that do not restrict, limit, or take away somebody's rights. And if we can get everybody to start with supported decision making, and don't just quit in 6 or 7 months and say this hasn't worked. You have to give it time. You have to give the individual time to learn and experience life, and support them to learn how to make well-informed decisions. So what doesn't supported decision-making agreements do? Again, this is just a different way of looking at the supporters here. So it does not give supporters any new rights. They have no authority at any point to make decisions on behalf of the decision maker. Supporters also cannot sign any type of legal documents for the decision maker. They cannot bind the individual into any type of legal agreement. They only have the roles and the authority granted by the decision maker under the terms of their specific agreements. Don't forget, make sure everybody has the most current copy of the agreement at all times. I also recommend that the individual shares their agreements with anybody who's expected to acknowledge and honor the agreement. So this is, of course, going to be your doctors, banks, could possibly be an employer or a landlord, people that, on top of just sharing with people that this is what they're using, especially in certain decision-making skills like healthcare and financial decisions, you're going to want to share this document with them so they know that you're utilizing supported decision-making. There are a ton of resources available. The best resource, honestly, is the National Resource for Supported Decision Making. This has information from every state. It's got past trainings, tons of sample documents. You can pull up different PowerPoints. You can figure out how each state supported decision-making agreement law differs or is the same. Really just a great resource. The ArcUS also has quite a bit of information. On our website at the Arc of Louisiana, we have a copy of this training, the slide deck, the sample agreement. We also developed a handbook, and I will send all of that to Chanel to send out to all of y'all. We developed a handbook that is great both for individuals and family members and potential supporters to sort of break down, go into greater detail, help the individual decide, what areas in life they're looking to get support in. So there's a bunch of tools in there to help them through that process. And again, I will send all of that to Chanel. If you have any questions about any of the information, if it is a question about legal status, if you call me, I'm going to route you back to Disability Rights Louisiana because I am not an attorney, did not sleep at a Holiday Inn Express last night. So I am not the person for those questions, but Melanie or anybody at Disability Rights can assist you further with all of like the legal stuff. But if you just have general questions about supported decision-making, maybe want some, assistance around it, I can answer all of those questions. And there is our contact information, our phone numbers, our email addresses. So that is it. And if y'all have questions, we can start answering some of those.
So we have, there are a couple of questions about the slides going out, which you addressed. There's one question here, for the agreement to be valid, it has to be notarized and then turned into whom? Or is it just notarized and saved by people involved and shown when applicable to situations?
Yes. So you do not have to show anybody, hand this document to anybody other than making sure that all of the supporters involved have the agreement. So not everybody has to go to the notary. So let's say you've got a big group. You've got, let's say, 8 different supporters. Not all 8 of them have to go to the notary to get this done. Let's say only 2 go. It's perfectly fine. But you're going to want to share the signed agreement so everybody has the most current copy at all times with all of the 8 supporters.
That's right. That was it. I don't know if anyone has any other questions or comments or thoughts or anything. You can throw them in the chat. I don't know if you're able to come off mute if you prefer to do that.
You're muted, Chanel.
I was saying if they raise their hands, I can take them off of mute because we are in a small group today.
Perfect. Oh, let's see, we have one come up here for tutorship. I heard that after death, there is no one to take over for the individual. What happens to the individual afterwards? Um, that's right. That's absolutely right. Once the parents of the child under a tutorship pass away, there is no one to step in. And either the individual or someone on their behalf can go to the court and either petition to have the tutorship terminated and have it ended, or someone would need to file for an interdiction. Um, both options cost money. One costs significantly more than the other. So yeah, that's the option. And I mean, if there is no one, we actually run into this a lot, where we have aging individuals who are, in their 50s or in their 60s even, who are under tutorships that were under tutorships from the time that they were children, and their parents are, long deceased. It gets very complicated for a lot of things, right? Medical care, for provider decisions. Fortunately for them, most of the individuals that we encounter have been with the same providers for 20, 30 years. So they've been with a group of people who know them, they trust, they're able to communicate the things that they want and need. And unless it comes up to something that's more complicated, the provider makes every effort to try and abide by the wishes of the individual for what they want and need. But it does raise a very big complication that can be really complicated and messy to overcome and undo. There is no uniform answer. It's something that we have to deal with on a case-by-case basis, because it's so individualized and so specific. So I will say that if anyone has clients, knows about clients, knows about just a human somewhere um, who's in that situation, please feel free to refer them over to us, and we'll do what we can to try and resolve the situation if possible.
All right. Do we have any more questions? And like I said, if you want to speak, all you have to do is just raise your hand and I can take you off of mute and you'll be able to speak instead of typing your question into the chat. And I will say, the question that I had about the webinar being recorded, the webinar was recorded and we will put it on our YouTube channel later today. So you'll get that notification. Also, when I get everything from Ashley and I send that out, I also put the link in that email as well. So you'll have the link there as well. Don't forget, at the end, when this webinar ends, there is an evaluation that will pop up. So please feel free to fill out that evaluation. That just lets us know that this information was relevant to you, and that it was also useful to you. Also, there's a spot on that evaluation where it says, do you have any more questions, or do you have any concerns or anything that you would like to know? If there's a webinar that we have not had, or if there's a topic that you need more information on, please feel free to put that in that section on that evaluation. Ladies, I don't see any hands raised. I don't see any more questions. So I just want to thank you for your time this morning / afternoon. Like I said, I just really wanted to get this information out, and I'm so glad that you guys were able to provide this information to our families and our community partners. So if that's it, I'll just give you guys the rest of your day, and thank you so much.
Wonderful. Thanks so much for having
me. It's good to see you.
All right. Thank you. Nice to see you too, Ashley. Bye-bye.
Bye-bye.
Bye.